All right, we are live, broadcasting today. Welcome everyone. Today is January 8th, 2025. Want to wish everybody a Happy New Year. It has been 3 weeks now since we have all met. We got a chance to enjoy a Christmas and New Year's break on these nights. Just so happened that those days fell exactly on our meeting nights, or else we probably would have pushed through. But hope everyone had some rest and was able to recharge and get ready to jump back into our discipline matrix, ad hoc, and some of the responsibilities that we are tasked with. And moving through this document, we've been making some very good progress. And as I had mentioned to our panelists and to the public, want to let you all know that I am currently in transit, so I will have my camera off for the next 10, 15 minutes, but then we'll be transitioning to my laptop. In the meantime, I will be passing it over to AC Hubbard. How are you, sir? Good evening.
Thank you.
Um, Hopefully you could give us a quick little recap of where we left off, and then we could just pick back on up and keep on working through this lengthy document.
Great. Thank you very much. We left off talking about three things in particular. We are on the tail. I don't know if you, hopefully you can see my screen here, but we were talking
Yes.
thank you. We were talking about subversive organizations. I think we're near final for that. I will go over that here soon. We also talked in detail about custody of prisoners, and I will go over those changes. And then where we stopped, well, excuse me, the tail end of our conversation 2.5 weeks ago or so was truthfulness. And I made some changes to that. I should delete that because I did make some changes, and I'll go over that. And then we agreed to go into use of force in particular. It's somewhat confusing just how it's listed. And so we can slowly talk about those sections. So just going back to the top here, subversive organizations, and I'll go ahead because I know one person is driving and some others may not be able to see my screen where they're at. No member or employee shall knowingly join, affiliate with, or support this. Those in green is a new addition. Any organization, group, or gang involved in illegal activities or designated by subversive, by a competent authority within the Oakland Police Department, including the chief of police or other law enforcement entities. Example: DOJ, FBI, the CPRA, or unauthorized designee. Such groups include, but are not limited to, organizations that seek to undermine, disrupt, or overthrow. We removed any form of lawful authority and just left it as overthrow established government institutions. This includes authority vested in federal, state, or municipal governments, city councils, or other recognized local governing bodies, or laws and regulations legitimately established under the jurisdictions of California, the United States, or other lawfully constituted entities. Additionally, any organization engaging in illegal acts against public order and safety may be deemed subversive. The designation of a subversive organization will be based on preponderance of evidence, demonstrating that the organization actively participates in activities intended to undermine, disrupt, or overthrow such lawful authority or commit illegal acts against the public welfare. Membership or affiliation with such organizations for any purpose related to advancing unlawful objectives strictly prohibited, except when such involvement is essential for official duties, supported by a lawful investigative purpose, and authorized in writing by the chief of police or a designated official. A lot going on there.
Yes, mouthful. Thoughts, Kathy?
So yeah, I'm curious. So we're only concerned about any illegal activities that would undermine any laws. But what about an organization, just throwing out a name here, the Ku Klux Klan? How would they fit within this definition of a subversive organization?
Yeah, thank you for that. I think that group has been deemed already subversive just by the title alone within the FBI. But one would have to look at the totality of the circumstances, and if any part of their mission or purpose is to overthrow some type of government authority through illegal acts, that would be then deemed subversive under this definition.
Right, but some of their activities aren't geared towards overthrowing the government, but harming other groups of citizens.
Right.
Yeah, that's a great point, Kathy. And I'm wondering if is subversive organization like could it be classified if they're promoting hate speech or hate against other ethnic groups and not necessarily against the government, or does that get covered somewhere else?
Well,
No,
yeah, I'm sorry, go ahead.
so I'm looking at this may cover it. Paragraph 3, the last, well, that's a whole sentence, but I guess the last 5 or 6 words at the end of that paragraph, or commit illegal acts against the public welfare. Would that cover those type of organizations?
I would say yes, and I think it's also like when you look at the legal definition of a subversive, I think the intent is against really government entities. I mean, there are different sections within our manual rules that would speak specifically to hate and bias against certain groups. I think
Mhm.
what's important here is even if let's say there's an officer who decides to join this organization and their intent is not to overthrow a government, but to do these other acts. Just the mere fact that they're part of this group whose submission, if you will, is overthrow the government, they would then be part of a subversive organization.
But a hate group within itself may not fall under that.
I mean, I can make the argument that if you're part of a hate group, yes, your actions are against the general public, maybe, but also undermine the Constitution, which is a government entity and what we stand for. I mean, yeah.
Yeah, I just don't see. I mean, I know that they. I'm just throwing them out because they are a group in Oakland that has a history. Um, I don't know of any attempt by them to overthrow the government, and that's why I was wondering if that last clause or commit illegal acts against the public welfare would cover those type of groups.
Right.
Along with you said there's another section that deals with hate crimes.
It wouldn't say specifically hate crimes, but it would be under obedience to laws, first of all, and then also just general
What about like repute?
that too, sure.
I'm
But
sorry, I missed that.
bringing disrepute to the organization.
Oh, okay. All righty. Okay.
So I would say just based on the title alone, and unfortunately, subversive only organizations only refer to some type of government authority. However, I mean, I think this is why we're here. If we want to create a standalone section that is outside of subversive organizations and just have you're joining any organization that go against the values of just society as a whole, we can certainly do that.
Okay. I wish Reggie were here because he would really be able to clarify this.
Yeah.
All right, we can always come back to it later when he's on the line. Okay. All right. I
Yeah,
feel
let's come.
comfortable with commit illegal acts against the public welfare. But I'm just wondering if we should have some other language too, which doesn't come to mind right now, but maybe we can pick that back up later. Reggie may have some clarifying language that he may like to include.
Are you saying that, or as you read this, that public welfare, the way it's written, kind of goes against the intent behind this, which is overthrow a government agency or institution?
It seems like it's too, it seems like this paragraph talks about two different activities. It talks about oh, there's Reginald right there. Let me take this from Reggie right quick. Hi. Oh yeah, we didn't realize you were on the call. Okay. We don't see you at all. Okay. Oh, maybe you're under attendees. Yeah, we see you under attendees actually. I don't know. You must be on the wrong link. You need a link to be a panelist and not an attendee. Why don't I send you that link right quick? Okay. Okay. All right. Thank you. Okay. So apparently Reginald is in under an attendee. And so I'm going to send him the link for panelists and get him to appear that way. Let's see if I can.
That would be super helpful, Kathy, because we had our chief of staff drop off already. But if you can't figure that out, I'll be able to take a hack at it too in a little bit. I think it was on one of the calendar invites.
Yeah, I have it here.
Okay, great. And then I'm glad Reggie brought our attention to some of the attendees, because we do actually, I want to acknowledge, we do have a member of the public in the audience as well. Miss Linda Nakamura, welcome. And so I will be checking now participants regularly too, just to see if there's any comments or hands up. Feel free to join the discussion, or if you have any thoughts that you could put in the chat, Ms. Nakamura, that would be welcomed as well.
Okay, so I just sent Reginald the link, and he'll be signing on momentarily.
Okay,
he said
great.
He could hear us, but he couldn't participate, and that's when I, said, well, maybe he's coming in as an attendee.
Well, I'm glad he called, because I'm sure he had something to say and was like, what?
He heard me say his name. That's why he realized something's going on here, and I'm not a part of this.
Excellent. I'm glad it brought it to our attention. So I'm also, so we'll wait for him to join. He should be joining us soon. Let me make sure that he's not in the waiting room.
Okay.
Well, not yet. But for consideration, Hubbard, would it be appropriate to add another sentence in this section that's specific, like around hate groups? Or would that be out of place in this? It feels like it would be out of place since we really are talking about government entities. Hey, Reg, how are you, sir?
And let me apologize. I don't know how that happened, but it happened. I was in.
So since I sent you that link, you're showing up as Kathy Leonard. So I guess that link was specific to me. So don't worry about it. We're at least on, so we know you're here.
Yeah. Wow.
All righty. So the question I was asking, Reginald, is the third paragraph under subversive organization.
Yes.
I was wondering if this section covered hate groups, like for instance, the KKK. And the reason I mentioned them is because they had a presence in Oakland at some point. So I was looking at the last clause in that at the end of the third paragraph, which says, or commit illegal acts against public welfare. And if that would include groups like the KKK or other groups that in their sole purpose, well, one of their purposes is to harm members of the public or harm specific members of the public. Would that cover this, or should we have a standalone paragraph or sentence that covers those type of organizations? And the reason that came up, well, so is it Lieutenant Hubbard?
Today is acting captain, but Brian is fine too.
Oh, captain. Okay, sorry. So acting Captain Hubbard said this section really goes to organizations or that affiliation with organizations that are trying to overthrow the government.
Okay,
The question was, what about other groups that are not trying to overthrow the government, but intend harm upon specific groups of citizens?
See, I follow your line of reasoning, and this is why we're here, really, because if we leave it like this, it will address no one, because who joins a group to overthrow the United States? Our problem has been with groups that organize to harass and oppress various people, be they women or foreigners or speak with a different language, or you know, that type of dynamic.
Right.
So if this section is just for subversive organizations, maybe Captain Brian's suggestion to have a standalone section that addresses, you know, racist groups that intimidate, like in like the Klan, but there are others, right? And then
Right.
and then write a whole new section that fits what we're trying to say. I want groups that harass immigrants and people of color and women and poor people. I want something that address that behavior. I don't, as this is written, it's a subversive group, so it has to be joining a how did you describe that, Brian?
Joe, those who want to overthrow a government institution.
Yes, you want to. Oh, but these guys that we have the most problem with don't want to overthrow the government. They just want to burn somebody's house down.
Correct.
Or intimidate them, or prevent them from seeking employment, or bully them. So maybe we need a whole new section for that. How's that sound?
It covers, no, that sounds excellent. And I think it is a whole other pot of issues, right? Organization or group that promotes hate against any of our protected rights, right? Against our LGBTQ community, against our Black and brown community, any of that.
And in fact, those are the problems. We have more of those type of problems than subversive organizations.
Exactly.
I don't have any memory of any group that wanted to overthrow the government. They wanted the government to change, but they didn't want to overthrow it. Maybe I could think of one or two now that I'm thinking about it.
Well, the interesting thing is the example we've used recently, and I know Pastor Peterson often brings this up, is the January 6th riot, right, and officers' involvement in that event. But I wonder how it complicates things once our new president gets sworn in and grants pardons to everybody and declares them heroes. Does that mean that all those organizations are no longer subversive organizations anymore?
Well, I do know this, that Oakland is a charter city, and that regardless of what the federal government says, City of Oakland can say, for our employees, we look at this situation this way. You know, we don't follow, the City of Oakland doesn't have to follow the thinking of whoever the current president was or happens to be. So the president can say everybody on January 6th is a national hero, but the City of Oakland can say, you know, if you are stopping the government in any kind of way, if you come down to City Hall and threaten the lives of the city council members and all of that, that's subversive.
Okay, so I think we're in agreement that we should have a standalone paragraph or section.
Correct.
Okay, we just have to figure out where that goes.
It would go before and after this. I'd keep it in the same. I'd call it 384.7.1 maybe. I'll have to figure that out. It just
Okay,
would have a new title. I think the challenge that I will have, it's not writing it per se, but who determines then? Subversive organizations, there's a lot of support within the law enforcement community identifying those. We have the Department of Justice, we have the FBI, but if we were going to have a standalone, we know the obvious ones, but let's just say an officer, creates their own, and like who's going to determine whether that then is deemed an inappropriate organization for the purpose of that policy or section. So that's something we can discuss in the future.
Yeah, they don't have to necessarily overthrow the government, but they could harass, intimidate, oppress protected classes. I'm thinking of historically this group down in Los Angeles where MAW, Men Against Women, that was formed in the LAPD, which was a sexist organization led by, and I'm blanking on his name, the officer that was involved in the O.J. Simpson trial. He started it.
Mark Furman?
Mark Furman, yeah, he started it. And the city of Los Angeles, responded to that severely to him and disbanded that group. So we have cliques in law enforcement, and it is the number one, not the number one, but let's say it is a major threat to civil order by law enforcement officers. And if we're going to be honest about that, we know that there are a lot of cliques, LA County Sheriff's Department, that are inundated with gang members, etc. It's been proven.
right, and we know in Castro Valley, the Ku Klux Klan actually had headquarters there, and a lot of officers. I don't know if Castro Valley is considered to be an unincorporated city.
It is.
It is.
Yes.
So members of the sheriff's department were members of the Ku Klux Klan. So I would consider that not necessarily a subversive organization, but an organization that was created to harm African Americans.
In other protected classes, I wouldn't say just African Americans. But
well, that was the main one.
Yeah.
So I think that no officer should be a member of that type of an organization. So we'll just figure out how to word it.
Yeah, and I mean that's I think an easy example. I think we're going to have challenges. Is not necessarily what does membership really mean, like paying dues, for example, versus what if I just subscribe to their Facebook? Is that association? And it depends on how far we want to go with what that means of what your association with this inappropriate organization really means.
And
You
we
must
have
have some, if you're on their Facebook page, I would assume that you're sympathetic to the mission of those organizations.
Mm.
And that would, in my mind, I think in a reasonable person's mind, that would go against what a group that police officers ought to be associated with.
Well, I'm thinking we can use some of the language, the behavior that harms the 7 protective classes. You're intimidating, harassing, threatening, then under the color of this group, then you don't have to be a dues paying member, but This is the behavior you're acting out.
Yeah. Although if you were a dues paying member or even donate to those type of organizations,
That would be
I
easy.
think that would just be crossing the line.
Yeah.
Even
That would-
donations would be crossing the line.
Or how about if you put tattoos and wear insignia? If you we have laws on the books now that if certain people, citizens, flash signs with their fingers, they can be arrested as gang members. So this is not uncharted territory, So if you putting tattoos on and wearing t-shirts, espousing, threatening, intimidating, offensive behavior designed to strike fear into a protected class, then you've crossed the line.
Agreed.
Okay, great. I will work on that for our next week meeting.
Thank you.
Okay, we also talked about custody of prisoners, and the backdrop for this was that currently it reads as this is crossed out, but it's only a class 1. And I'll just refresh our memory on this because it's been a few weeks, but basically it's very broad. So, the physical abuse of a prisoner like that of Freddie Gray that happened in Baltimore, I mean, that's the extreme version, but in the same section, we could sustain an officer for not allowing one to use the restroom. And just the humiliation, I guess, behind that, whether intentional or not intentional, it's all in the same family. So we wanted to create a class 1, which is a more severe definition. I'll go over that. Inhumane treatment refers to any deliberate, intentional, or callous, that's an addition, act of neglect, abuse, or mistreatment toward a prisoner that violates established standards of care, resulting in serious harm or creating a substantial risk of harm. This includes denying access to restroom facilities, refusing necessary medical care, engaging in physical, verbal, or psychological abuse. To ensure clarity, inhumane treatment excludes brief context-dependent delays that arise from operational necessities, provided such delays are reasonable, documented, and promptly addressed. Then we created a class 2 section, which is not as severe. General neglect or procedural deficiency involves non-deliberate lapses in prisoner care resulting from technical oversights, procedural mistakes, or minor compliance failures. These incidents lack malicious intent but may still compromise prisoner welfare. To address varying levels of severity, the classification distinguishes between minor technical errors with minimal operational impact and significant procedural breakdowns that pose greater risk. Corrective measures will be proportionate to the severity, frequency, and resulting consequences of the failure. I think we are satisfied with how it was written. There's going to be certainly a training component to this too, because there's some overlap there on what that really means. And I'll tell you the most general one. I'll go over this again. We transport our prisoners all the way to Dublin, and if it's in the middle of the afternoon on a weekday, getting to Dublin from Oakland can take a very long time. And halfway through, someone may want to use the restroom, and we do not have a logistical answer for that. It would be great if we had, little rest stations between here and there where we know that we can stop, but it just doesn't always work out that way. So we teach officers to be aware of it, don't ignore it, but also no, you shouldn't. You can't stop at someone's house, knock on their door, and say, "Hey, I have a prisoner that needs your restroom," and then we'll sustain you if you don't do it. So we have to find a balance of both. But that's why we have this class 2, if appropriate.
Makes sense.
Okay. Any questions on custody of prisoner?
Hey, sorry, I couldn't find mute. No, that's great. I think the language captured much of the discussion that we had. And as I mentioned before, and being in recent disciplinary hearings where we had to deal with custody of prisoners, it would have been great to have a class 2 option, and to be able to distinguish between the egregious nature of a violation versus more of a procedural violation. And so I think this hits it on the head right here.
Mhm.
Great. Okay, truthfulness. This is how it's written right now. I'll go ahead and read it. This is our current definition. Members and employees are required to be truthful at all times, whether under oath or not, except when necessary in the performance of official duties. Such exceptions shall be documented on the appropriate police reports. I think we agreed that we didn't really want to change this much. However, there was a discussion regarding juvenile custodial interrogations. So I did a little bit of research. I have a very simple addition to this, and I'm open to having a conversation further. So in compliance with California Welfare and Institutions Code 625.7, members are prohibited from using threats, physical harm, deception, or psychological manipulative tactics during custodial interrogations of persons 17 years of age or younger. Exceptions apply only when there is reasonable belief of an imminent threat to life or property, or questions are strictly limited to addressing the imminent threat, or I should say, and their questions are strictly limited to addressing the imminent threat. So that's really taken straight from the law, but I'm open to a further conversation on that.
So, when you say custodial interrogation,
Yeah.
do you mean that the juvenile has not been arrested, but you're questioning them?
No, they're under arrest. Custodial
They're
interrogation.
actually under arrest.
Under
Okay.
arrest, yeah, not detained.
Okay.
And it's a great question because we did bring this up. It's like, so what if and I'm just going to be the bad officer here, I don't place them under arrest. I'm just merely detaining them. And therefore I can use psychological manipulative tactics, but with the intent or even the probable cause at that point of placing the arrest, I just don't officially do it.
Yeah, but even if you're detaining a minor, should the police be using these sort of tactics? Shouldn't the parent be present? I mean, if I have a minor, I certainly don't want an adult questioning that child, particularly since officers people may think that they have to comply with whatever the officers are telling them, or believe that they should give statements when perhaps they shouldn't be given a statement, so their parents should be present.
Yeah, no, that's a great point. I think that's one of the reasons why this law was created. But yeah, one, we don't always come in contact with juveniles with the parent present, and the law or policy doesn't state that we do have to wait for that to be. But there are a lot of danger zones there. Obviously, it's like, so you shouldn't be taking advantage of just someone because of their age and getting them to say or do something that you wouldn't do also for an adult. But just again, quoting the law specifically, it doesn't outline that. But we can. I mean, that's why we're here. So whether we want to elaborate more on this or just have it mirror the law.
I think we should elaborate, because I don't think it's fair to question minor children without the presence of an adult, a family member, or someone under whose care they're under.
So I'll clarify a couple things. So this is in regards to truthfulness. So let's just say I don't plan on using trickery or subterfuge when speaking to this juvenile. Let's just talk straight about interviewing juveniles. And we do have really two separate policies that address this. Do we want to take the position that an officer shall not, and that's the language we use, speak to a juvenile unless an adult is present?
I think so, because once you start using threats, physical harm, deception, or psychologically manipulative tactics, now you've got children or minor children who will never trust a police officer again. And if we're trying to get the public to trust police officers, you may need them in a witness in some other case. They may call the officer if they know some crime is being committed. Or not call, but have someone call on their behalf, a parent or something. They're not going to feel like they can trust the police to do anything. We're trying to engender some trust here. This undermines any trust that a minor would have with a police officer. I don't think that's the direction that we should be venturing towards.
There was a time under the Welfare Institution Code when you could not interview a juvenile without the consent of a parent. They didn't have to be present, but they had to give consent. I'm old enough to remember that. And so it left that kind of protection, and they start treating juveniles more like adults by lowering the age. You know, I think when can you charge a juvenile? I think at 14 now, right? As an adult.
Right.
Yeah. So when they start lowering the age, then they say, well, then we ought to be able to use any kind of ruse or subterfuge that we want with them, with or without their parents present or permission. So again, Oakland is a charter city. We can do what we want.
So I have to apologize for the group. I was transitioning to my laptop and was trying really hard not to end the meeting for everybody in the process of doing that, since I was the host. And I kind of caught the tail end of when you're reading the language on that, Brian. And so, and I know we had initiated this discussion, and I thought there were new laws that were taking place either last year or this year that prohibited a level of interrogation for minors, or they had to have the lawyer present, or I'm sorry, I think, and I'm probably making you repeat yourself. So
Yeah, no, it's fine. And yes, they do have to have a lawyer present. So we're only talking about custodial arrest. The Miranda process, we have to call the public defender. But this section that we did talk about, 625.7, this also speaks to using threats, physical harm, deception, or psychological manipulative tactics during a custodial interview for those persons 17 years or younger.
it prohibits those tactics.
I'm sorry?
Those tactics are prohibited.
Prohibited, period. Yeah, except for when there's a reasonable belief of an imminent threat to life or property, and the questions are specific to those items. So the question that came up then is, I mean, this is the section under truthfulness. Can I now, what if I just don't arrest the juvenile? What if they're just merely detained, or it's just a mere contact of a juvenile? There's no adult present, let's say. Can I now use this deception, subterfuge, etc., to get what I want because they're not in custody? Or do we want to make this more restrictive?
Well, I could see that as a tactic being used. You could say, okay, well, since I know that I can't do this during a custodial interrogation, then I'm just not going to arrest the minor. I'll just do all these other things that I normally could not do by just saying that you're not under arrest.
Right.
And so, for clarity, though, if they don't get placed under arrest, they do not read the Miranda rights. Anything they say prior to that, though, they could then in turn around and arrest them and use those words against them, right?
Right.
I think it's an unfair tactic.
And it will be used.
Yeah.
Without a doubt, it will be used. The unfair tactic. So how do we correct this? Can we say officers shall not use any trickery or by interviewing a person prior to an arrest with the intent to arrest?
Certainly, well, we can just say the members are prohibited from using any of these things when during any contact or communication with a person 17 years or younger.
Right.
But in
I'm comfortable with that language.
but in order to determine if somebody was 17 and under, they would have to at least get their ID and establish that. And they could do that without doing a formal arrest.
That's right. Yeah. Yeah. Like for a detention, officers are allowed to demand that information. You know, and so that's part of the investigatory process of obtaining that information. You know, where we can run into problems with this is, you know, trying to elicit incriminating statements from them by using trickery. You know, I'll give you the classic example of, you know, a juvenile says, "Oh, I that wasn't me who ran from the stolen car," and then you can lie and say, "Well, no, I looked at surveillance footage and it clearly shows you." It's deceptive. It's allowed legally by law, which is interesting. But under this section, our OPD section, we can outlaw that. Under California law, though, that would be allowed because they're not technically under arrest at that time. So we could just make it more restrictive, and that's fine.
Yeah, I guess I'm just uncomfortable with officers using any type of tactics against children. I'm uncomfortable with it. I'm uncomfortable with them doing that to adults. And so I'm certainly going to be uncomfortable with them doing it to a child. Some children are very immature and easily manipulated. And I'm just uncomfortable with it.
And we have to understand that the law does allow police officers to lie, to use.
I know.
They call it a
ruse.
ruse. They call it a ruse, you know, and that's the technical term for it. This is not going to go over well with the officers, but and maybe some people who think that this is how you fight crime. But I have to agree with you. Listen, you know, no trickery for juveniles. We're just talking about juveniles.
Exactly.
So don't lie to them. Don't trick them. Don't tell them your friend just confessed that you did it.
Yeah, no doubt. No, I definitely agree with everything being said here. I think the application of it is what I'm struggling with it right now and trying to like see how a scenario will play itself out. One reason is because I know a lot of juveniles that I work with that are under 17 that they don't carry ID. They don't have a license. They don't carry ID, right? And if I'm and now I know I'm getting ahead of myself, but I also understand how certain loopholes get manipulated. And if I'm 18, 19, 20 years old, I'm like, I don't have an ID and I'm 17 and I'm just lying. At that point, like what happens in that case, Brian? Like you would have to get fingerprints, and how do you determine somebody's really a minor versus not a minor? Or if you really have a minor that doesn't have an ID, I'm thinking about my 15, 16-year-old that, you know, she just recently got her ID, you know, a year ago, but there was a point where she didn't have an ID other than her school ID, right? Like what are the ways, what's the process an officer would take to determine that somebody's actually a juvenile?
I mean, usually we can ask, usually it just comes out through the interview process. You know, with the use of cell phones, a lot of the juveniles are able to easily prove it just with the data that they may have in there, but it's also the availability of some type of competent authority that can come and verify it. It's rare that we'd be in a situation not being able to identify, but it's like more so than just investigating, let's say, a crime. We also have to care for their well-being, and so we can't just say, well, we can't identify you, see you later. We have to make sure that they're cared for. And So the worst case scenario is we would take them to juvenile hall just for identification purposes, but that would be the absolute last resort where nothing else is available. Rarely do we get to that point. Usually we're able to bridge the gap.
And,
What about contacting a parent? Does that ever happen?
It does, yeah, and that's really
Verifying age?
yeah,
Right.
that's what we're aiming for, and it's also just to relinquish authority. So often we don't encourage juvenile arrest for many reasons. But if there is a situation where we have to arrest, let's say we do find the juvenile driving a stolen vehicle, the end result for that is usually relinquishing that juvenile to their parent and then issuing a notice to appear. So they do have to answer for the crime, but we're not sending them to jail for that. It's a parent's responsibility. Yeah.
and we have to keep in mind that the burden of proof is on the state.
Yeah.
So, if we don't know if a child is underage and it says, hey, look, I'm 15 years old. Yes, I have a beard, but I'm 15 with a beard. It's our obligation to prove it. Our being law enforcement.
So then in
Well,
this,
that situation certainly does arise. My brother at 14 had a beard,
Yeah.
and he was he was playing basketball at No Name Park
Yeah.
and had his nose broken, just a friendly game. And he went to Children's Hospital and they kept calling him sir. And he said, I'm a child, and they kept saying, sir, you have to go to an adult hospital. And so, my dad had to, get my mom, and, he had to get off work and come and prove that he was in fact a minor. So there
I
are
had
instances
that.
where some
I had
kids
that problem.
do look like grown people.
I had that problem. I was tall, 6'4", with the goatee.
Yeah.
And 16 and 17 years old. So
Yeah.
it happens.
so then in this scenario, then the onus would be on the officer
Always.
to make sure that this kid is not a juvenile, that he is 18 before I start using any ruses or any start trying to manipulate an
Always.
Yeah.
Without a doubt.
as long as that's reasonable. I just don't want to put folks in positions that are like, that's impossible for me to determine, but it sounds like it's pretty straightforward to determine.
Yeah, it doesn't stop the police officer asking what happened here, what went on, were you involved? You can ask those questions. If the guy is not telling you the truth or you think he's not telling the truth, you can only deal with the questions, the answers that you receive from him. You can't start using the kind of tactics that you would use on, a two-time loser, convict.
No doubt, no doubt. And I also want to just highlight for the record too, Ryan, and maybe there's something we can think about at some point beyond, when we're talking about maybe confidential informants and other things like this, right? I mean, Kathy was speaking to a very important part about community trust, right? And to take it a step further, even community violence. A young person is impressionable. They could easily get manipulated, say the wrong thing. 2 days later, he's labeled a snitch and is dead now. And all because an officer chose to use some shady tactics on a juvenile. And so that's the type of responsibility that I want us to be able to understand the ripple effect of those type of actions. Obviously, confidential informant is a whole other world, right? But it's very similar in which a young person, we want to protect them from even being manipulated in a way that they'll put themselves in harm, put their community in harm. And then in turn, everybody in the community ends up saying F the police because of this type of behavior, right? That led to these outcomes, right? I could imagine a mother if her son, God forbid, was killed because he got manipulated by it and said the wrong thing, and now he was able to snitch. 2 days later, was killed. That mother, that family, they're never going to trust the police again, And so we're looking at levels of these trickle effects, and so I think as complicated or as maybe not bought in as officers might be, because it's going to be a pain in the ass. This restrictive is going to be another pretty restrictive thing. I think it is very, very important for us to be able to include that those levels of restrictions when it comes to juveniles.
Yeah, no, thank you for that. I will ask though, just because we are talking about truthfulness. As we discussed before, this is a termination offense. The first, there's nothing beyond that if you get sustained for it. So I want to make sure that we're categorizing this in the appropriate way. let's say that an officer during a custodial interview lies to a juvenile, are we then going to terminate that officer? Or are we more talking about just demeanor issues that we should carve this out to some other section?
Truthfulness right now, it's a class 1.
Last one, automatic termination.
Right, and sometimes that doesn't happen. I mean, my understanding is that lying is a fireable offense, but I've seen many instances where an officer lied and he's still on the job. That's a problem.
Right. I mean, yeah, I guess if sustained for truthfulness after the investigation, then they would be terminated. There's no other option for the chief. So this is where we have to be careful with this section, because are we going to call the member a liar if they use this tactic against, let's say, a juvenile, for example, that we deem to be inappropriate?
Well, in the case of like we did with the custody of prisoners, I think that might call for a class 2 violation that's more procedural, right? Because technically they could do it with adults, but I messed up procedurally and did it with the juvenile, right? I don't know, but then it's subjective in terms of like the malice and intent and all that, right?
Yeah, it's almost like we're being somewhat forgiving about being untruthful, and I don't think we want to take that position. I almost see this as like maybe having a section, because it seems like, I appreciate all the perspectives, just we don't have a juvenile interaction section that could cover a lot more than what we're talking about here. Just how you address them, how you facilitate their needs. Maybe it's just juvenile interaction section, and it could incorporate what we're talking about here.
We have recently committed to exploring with our community an ad hoc that would look at police restraints, handcuffing, and juvenile policy around that. Would that be more appropriate in that?
Sure. Yeah, I think so.
Because that's more procedurally around like how arrests are made, how you handcuff, how you detain people, the differences between what you do with juveniles, and it feels like it fits in that a little bit better, maybe.
Right. Yeah. I mean, I think it just speaks to the overall care of the juvenile, not just in that moment, but future interactions, like it was stated. I just think there's so many different variables to that would support that standalone section. I think that's worth our while exploring, certainly.
Okay.
All right.
However, we're going back to truthfulness. I mean, if an officer egregiously lies and manipulates a juvenile, like we don't want that happening either, where they're knowingly lying and not being truthful. So then it would apply to this section.
It would. I think there is a carve out there, and again, this is somewhat of a last minute realization for me as I look at this. So I can still mess around with this definition and see if I can get something very specific to juvenile interactions, but it would almost have to be somewhat of an extreme version of that, where it's like intentional to create harm, not just what could be construed as a lie. I don't know. I have to be careful with that.
All right. It sounds like there's some musing over that you might need to do with that. And is there a way you can reference? I guess you can't reference a policy that hasn't been looked at yet either. The potential to restrain, all of that stuff.
I'll make a footnote in there just so remember to go back to it. We do have a handcuffing policy. We also have I believe the commission was instrumental in this policy, a community policing policy. I don't know how long ago that ad hoc was, but like, for example, within that is if there's ever an interaction with a juvenile, we're supposed to give them an informal business card, which gives resources. And that's like a technical issue. Like if an officer doesn't do that, there's really no section that addresses that, but it would be more appropriate in a juvenile interaction type umbrella of a section. So anyway, it'll give me something to do between now and Wednesday. I'll be happy to mess around with this some more.
Awesome. Let me just check real quick, make sure we don't have any comments or any participation in the audience. Okay, no, we're good.
Okay, great. All right, then I introduced this at the last meeting, but we wanted to next talk about use of force. So the way it reads now is use of force. This is level 1 through 4 shall be restricted to circumstances specified by department policies and law. So this is interesting where one can read this as excessive force, let's say. Excessive force is a very strong word. There's a difference between abusing someone, excessive force, versus force that we determine to be out of compliance because of there was a better alternative or the tactics were not sound or various. So we highlighted this to elaborate more on this, on what the expectations are. I know the discipline committee, the CPRA, internal affairs have sustained a lot of people for this, but it has just so many different meanings behind it. And I'll give you an example of how complicated this is. I made a note here. There are 4 levels of force, and each level has various force options within it. A level 1, for example, it includes any force resulting in death, any intentional firearm discharge at a person regardless of injury. So if I miss the person, it's still a level 1. Any force which creates a substantial risk of causing death. The use of a vehicle by a member to intentionally strike a suspect shall be considered deadly force. This includes any vehicle speed with or without injury when the act was intentional and contact was made. Then it goes into serious bodily injury and what that really means. Any use of force resulting in loss of consciousness and protracted loss, impairment, serious disfigurement, or function of any bodily member or organ includes paralysis. Any unintentional firearm discharge where if a person is injured as a result of the discharge or as directed by the CID commander, that's our investigations commander. Any intentional impact weapon strike to the head, and then any use of force that is elevated to a level 1. I will say that this is an older policy, so one more thing to add to there is California restricted the carotid chokehold, if you will. We don't call it chokehold here in California, but the carotid hold, that is considered, it's now completely banned, of course, but let's just say an officer did use that, we would consider that to be a level 1.
Right.
So there's a lot of implications here. And here's the danger of us kind of manipulating this or even talking about it, is that there's a residual effect that happens with these decisions. So let's just say today we decide anytime an officer tases someone, uses their taser against someone, we want to make that a level 1. That would be problematic because there are a lot of things that occur when that light is switched, to include how we investigate it and then the aftermath of it, of who looks at it and how we assess the overall compliance of it. Same things for level 2s and levels 3s and level 4s. They all have a different review process and how it's logged. And then of course we have the independent monitoring team that, I mean, these are tasks within the NSA, so they're being actively monitored. So there's just a lot of residual effect. But for the purpose of this section alone, this is the definition that we're working with. Any use of force, restricted circumstances. So basically, if an officer violates our policy regarding use of force, they're going to get sustained for this section. And it's a class 1 offense.
Have there been challenges or examples where, again, it continues to be a common theme where like we need to explore a class 2 offense in use of force? Or are there, and I'm looking to you and Deacon Lyles around just where are the loopholes? Where are the where are some of the problematic things, or if this is pretty sound, is it something that we just kind of don't touch? It's just like such highly monitored through the NSA, through the risk management meetings, and all of those other areas.
Certainly, I have a couple of examples, and I would say I think we've been able to figure it out, but there's just general confusion amongst the leadership. I'll give you an example. So an officer points their firearm at someone, and let's say it's justified. Okay. In our use of force policy, it says that if you point your firearm at someone, if reasonable, you shall explain to the person why you pointed your firearm at that person. Not at the moment, but during the encounter, right? Hey, it's like, hey, listen, I got a call of a robbery. You were described as a subject on scene. I pointed my firearm at you, and it's just procedural justice. Okay. An officer fails to do that. That is a violation of our use of force policy. Is that a violation of the physical force section? That's an example.
Or the procedural part of the policy.
Right. So we're not saying the force is out of compliance or unreasonable. We're just saying you didn't follow a section within the use of force policy. So it's more, I don't want to water this down, but it's a technical violation.
And that would still be considered a class 1.
It can be. There's argument both ways. Some supervisors, they say, no, I agree that it's a policy violation. I'm just going to make it a performance of duty general, kind of the catch-all section that we talked about before, where you just didn't follow policy and you get sustained for that. If I may, I'll continue, and please interrupt me, but our use of force policy, again, it's somewhat new, 2021. We go beyond what the constitutional standard, if you will, of Graham v. Connor. So Graham v. Connor, they assess the alleged crime, the immediacy of the threat, and the active resistance of the subject. But our policy adds also the reasonableness, necessary force, and proportional force. Okay. We can say that the force was objectively reasonable under Graham v. Connor, but still violate our policy because it wasn't necessary. So that's another one where it's like, do we really want to say that the officer's physical force was unjustifiable class 1 versus there's a better way you could have handled that situation? Yeah. It's tough.
So then, given a circumstance like that, there just has to be, like, how would you determine what level of force that was that they violated?
Yeah, I mean, it would the levels were defined.
Yeah.
I'm sorry.
Because technically, the force itself wasn't a violation.
Well, I mean, technically it would be. So let's say the officer tased someone, and the most common scenario is, again, a little bit more restrictive in our policy, but the person's running away. And because they're running away, I elected to tase them because I wanted to overcome their resistance to effect that arrest. That alone is a violation of our policy. They would be sustained for a level 3 use of force, but this section of a class 1 370.27. But, in a strange way, if I, let's say, shot someone or they are, seriously injured and you held it out of compliance, I would get sustained for the same section. So there's no, it's almost like custody of prisoners. There's no in between. It's just like, it's all or nothing.
So if you tase, I'm trying to wrap my mind around this. So if you tase someone for a nonviolent offense, where would that fall?
If the investigation determined that that force was unreasonable, then it would be this section. It would be use of force, class 1. Yeah.
All right.
And we don't look at it as the outcome. So let's say I tase at the person, but I miss. It's all in the same family.
Yeah,
If I point my firearm at that person and the sergeant says, I don't agree. I think that you shouldn't have pointed your firearm. It's this offense. If I shoot someone and they're injured and I shouldn't have shot them, it's this offense. So there's, to see this wide range.
yeah.
Yeah.
But if you point your weapon at someone, that's not really a physical force, though.
It is. Yeah,
Yeah,
It's
it is.
considered to be,
Yeah, it is.
it is. Yeah.
because physical means you actually touch someone.
No. Yeah, I hear what you're saying, but it's
It's not a it's a physical threat. That's what it is. It's a threat,
Oh.
and it's a deadly threat.
All right. Okay.
yeah. It's
So
a-
we should consider a class 2 more technical allowance, or breaking it up to where we could actually classify some of the technical mistakes versus the actual use of force.
Yeah. I mean, that's just a consideration. It's just, I don't want it necessarily to be outcome based, but I think, we want officers to report their force, and over the years it's grown. I mean, we now, if we use any strength to overcome one's resistance, however slight, that's a reportable use of force. And we want that, uh, for many reasons. Uh, but to then say, and let's say there's no injury, nothing, but to then say an officer's out of compliance and hold them for a class 1 offense, which actually Senate Bill 2 has to be reported to California Post because it's in that family. I don't think it's proportional to the severity of like using abusive force against someone, which carries much more weight.
It almost feels like it's definitely a case to case basis, because I could also see just pulling out a gun and not using it or anything, but doing it in a very terrifying way where you could scare the shit out of somebody. Like it could really be intimidating,
Right.
Yeah.
Yeah, it's a lot. It's a lot to digest, and I have a lot of examples. And one way I think Seattle does is how they analyze force. They use it as outcome based. It's not necessarily the force they use, but also what was the aftermath. So I can use very minimal force, but the person can be severely injured. I can use an arm bar technique, and I can break their arm. Let's say, I mean that is minor force but severe injury. But I can also use severe force with no injury, and there's no in between there. So it's like it is a case by case, and so we could look at it as what was the outcome of this force. If it's minimal and yet you're wrong, we can maybe push it to a class 2 section versus the egregiousness of what you did coupled with the outcome or perceived outcome based on how severe it is. So that's another option.
Is there any downside to looking at something outcome based?
Sure. I mean, it could be like, well, I know it's a class 2, so there's it's not as severe as a class 1. So let me try this, or, use force when I typically wouldn't use force. So sure. Yeah.
Or you could try shooting somebody 5 times and miss all 5 times. Right. I mean,
Yeah, that's a little much, but yeah, I hear what you're saying. I mean, shooting might be an extreme example. I think I would always call those class 1s, but I mean, maybe since we do itemize force by levels, I mean, level 4 is the least severe use of force just on its face. Maybe those should be more class 2 considerations. I don't know.
and what would it look like to carve out a class 2 violation for that? Like, would you have to be very specific to it being like a technical type? Like, what type of offenses would you have to carve out for that to be very clear, so it's not so subjective either?
It's going to take me some time to work through it, but I'm thinking of force that can be deemed less desirable in our use of force policy. It just, there's disagreement of whether it was, necessary, let's say, or proportional, as in, Officer A used this maneuver, but Officer B could have used this maneuver, and that maneuver is better. It would be those types of, but it would be also outcome based. I would have to, the burden would be on me as the investigator to say, even though the tactic was wrong, there was no injury, there was no complaint of injury, there was no hospital admittance, things like that to further bolster my argument of why it should be a class 2. So something along those lines.
All right.
It's going to be a challenge, but I like the challenge.
Good.
And would it apply to all 4 levels of force? How, like for all 4 levels, there's like a corresponding technical violation that could happen?
I really find it hard to make a class 2 for a level 1 because the force would be so severe. Level 2, there might be some room, but definitely level 3s and 4s. I just think that there are, let's say, the taser deployment, where it doesn't strike the person at all, and sometimes they escape, and so the complainant in that is a John Doe, like we don't even know who the person is. If a supervisor is reviewing that body-worn camera and says you should never have tased at that person, they would get a class 1 sustained out of that. So what if there's no injury? What if it was just a poor decision? So I can make it the argument a little bit better as we get to the level 3, level 4 category. Maybe we'll see. Once I start writing these things out, it doesn't pan out as I wanted to, but we'll see.
Well,
Yeah, and maybe if you want, I can give you more examples, but I'm trying to look at it through your eyes also on the discipline committee. If I gave you that scenario when we're sitting in front of you, I mean, you're only forced with this level 1, but here Brian Hubbard walks in and says, but there's no injury, and there was the officer thought this during the heat of the moment, and the response, hey, there's only a level class 1 section for this. Yeah.
yeah, I mean, and to the other point of like custody prisoners, like just having that option is preferred on our end, I think, to be able to have that, be able to make that level of determination.
The range for this section is counseling and training all the way to termination. Yeah.
And if there was a class 2 related to this, then that range would be smaller, right? It wouldn't go all the way to termination.
Depending on I mean, it might be an incremental range because the progressive discipline can cause some problems for the officer.
It could maybe lead to.
But I think it would be better defined so you just know what you're looking at and why, so I'll take a shot at it.
Okay.
All right. The next one that I have on my list for today is another confusing one: refusal to provide name or serial number. The definition right now is upon request, members and employees shall supply their names and serial numbers to any persons who seek identification. We briefly went over this, I think it was like 4 weeks ago, but
Yeah.
we wanted to make a class 2 consideration. And for those who don't remember, I'll give you an example. If you ask me right now, what is your name and serial number? There's no excuse for me not to give that to you. There's no excuse because it's like I'm here in front of you. There's no stress. There's no one yelling at me. It's just, it is what it is. But we have sustained officers for this, for situations where it's a little bit subjective on whether they actually heard the person ask. Officers have been sustained for this when they're literally in a fight with the person and the person is, saying, what's your name? And the officer doesn't give it to them. at that time or even later. And then they say in there, hey, I would have if I processed even what they're saying, but I was in the middle of a fight. Or we have a lot of scenarios where there's a large crowd, and let's say it's a homicide scene, and sometimes we get a lot of community members that they're angry, they're hostile, yelling all different things, and from a corner like, hey, what's your name and serial number, to all the officers on scene, and one officer doesn't process it accordingly, but it's heard on body worn camera. We have sustained for this section refusal to provide name or serial number, and this is a Class 1 offense. So possible consideration of having those set of mitigating factors where it's not just a straight, I'm not giving my name or serial number. There are some mitigating reasons to why the officer did not do it at that time, but also not diminishing the importance of doing it and making it a Class 2, or in addition to a Class 1, a Class 2 section.
I don't see any problems with that. I think that's pretty straightforward. Now, the only thing I'm be concerned about it is that it becomes a loophole that officers know, okay, if I just say I forgot or I didn't hear, like there's certain keywords that I could say that make it a Class 2 or make it more believable it's a Class 2. I would hate to like provide that out for them to be able to manipulate that loophole.
That's right.
Well, let's say an officer's doing exactly what you're suggesting, Ricardo, and and he gets away with it the first time, and that's that person's habit. They do it again, and now this is the second time this has happened. We gotta discipline you more severely now. Why aren't you hearing people? Why are you? Well, I just didn't hear them. I just wouldn't believe them. I suggest this, that in all circumstances, just give them your phone number, your badge number, and your name. The only reason why they don't do it is because they don't want to have to give off the attitude like I'm beholden to you. You're telling me what to do. No, I'm telling you what to do. What's your badge number? What's your name and badge number? It's the smart thing to do is Reggie Lyles, badge 1, 2, 3, 4, 5. And it's done. And if they say, well, I didn't hear them, okay. But they were right in front of you. Why didn't you hear them? I just think this is a matter of training. I think all officers should just say your name and badge number. Just don't make an ego trip over it, where it's a tug of war. What if people were screaming at me? Well, scream your name and badge number. And then you don't have to worry about that. So I don't think it's any excuse for officers to say, this is why I didn't give him my name and badge number. When the law is clear about that, we have to have it on our chest, and the number on your chest and on your side of your, on your helmet. Just give your name and badge number and stop ego tripping. See, I didn't hear them. There was a lot of people. I didn't hear them asking me for my badge number. Okay, I'll accept that. You're wrestling with somebody, you're trying to handcuff them. But if they ask again and it's all on tape while you're driving them down to the station, what's your badge number? What's your badge number? You still haven't given it to them. There's just no excuse for that.
Yeah, agreed.
This is easy.
Yeah, I agree. And don't officers carry cards with their name and identifying information on it?
They do.
Yeah, it's just so easy to give that out.
Yeah.
You could even say that into the mic. I'm giving you, your body camera. I'm giving you my card with my identifying information on it.
Precisely correct. Just say your name. This is a matter of training. This is not the time to show that you are, you know, you have all authority. This is one thing that you should just tell them. And the quicker you tell them, the better.
And I would think in a volatile situation, people are going to be asking for the information anyway.
Yeah.
I mean, it could be pretty much assumed that if there's a confrontation, a verbal or physical confrontation with an officer,
It's almost
the
like
citizen is going to ask for your information. It would seem like that'd be a given to me.
yeah, it's
Ask
almost like if you ask an officer for his name and badge number, the officer perceives I'm being punished. I'm being reduced in my human status. No, just, hey, here's my badge number. Here's my number. Here's my name. Here's my number. Anything else you need? No? Okay.
Yeah.
See ya.
So am I hearing you both say that you'd be against a class 2 consideration? That is pretty straightforward. It's either class 1 or not.
What is it now?
It's a class 1.
Last one. What's
I
the
wouldn't-
discipline?
I wouldn't stop them. I wouldn't back away from that. I want them to be, I want them to do it. Look, it's class 1. So you don't need that kind of grief. Just tell them your name and your badge number.
And it's so easy. It's so easy to comply with.
No skin off your nose.
Right.
Just give it. We make it a class 2 and we give them an out and the blah, blah, blah. It's not going to increase the sharing of the name and badge number. It's going to reduce it.
The class 2 consideration would be in addition to the class 1 level, or
Yeah.
like you would break up like different scenarios, or it would be again just like the custody of prisoners would be something more technical or not as egregious. The one thing
I don't think if you can say that you were in a riot and there's a loud noises out there, you can prove it by your camera that you can hear the din of the noise going on out there. I didn't hear anybody ask me for my name. I'm not holding any officer responsible for something like that. You know, that's a possibility. It's logical.
We have.
But yeah, but what happens is you're arresting somebody and they're demanding your name or what their relatives are or friends, and you're ignoring them. Just tell them your name.
Agreed. Yeah, it's the intentional act that is easy for us to prove, and absolutely, there's no discussion there. It's where there is a possibility that it's the officer may have not heard them based on the circumstances, but the problem is that all we have here is a class 1, and supervisors are often reviewing just body-worn cameras. So they heard the person say, "Can I have your name and serial number?" The officer is 10, 15 feet away dealing with something else, but we don't really make that argument. It's like, hey, they asked, you didn't do it. It's a class 1.
Well, listen, they asked, you didn't do it. They were 15 feet away or 20 feet away. I heard noise in the background. It's possible that you didn't hear it. Okay, you get the pass on this one. If I'm the sergeant, I'm not trying to say, you know, this is not a felony, a cardinal sin. Okay, we know who you are. We ultimately know what officer was involved with this situation. So we've identified you. And okay, listen, next time I'm gonna counsel you. Next time, look, give your name out. And that's it. That's not even punitive. And that's the end of it. But if Reggie Lyles comes up and this is his 4th time he's using the same excuse, I didn't hear it, I'm telling Officer Lyles, I don't believe you.
Right.
If I'm his sergeant, I'm saying, Officer Lyles, I don't believe you, I'm sorry. And, you know, you got to do better here. And it seems like you had 3 other times here that you did not hear someone ask you for your name. I think you just don't want to give it out. So, sustained.
Yeah, then that's an easier scenario, and we do, and that's well, there's no really questions asked. It's again
I guess what I'm saying, Brian, if you run across those scenarios, those few scenarios where there's it's hard to determine if the officer heard it or not, side with the officer. You didn't hear him. Okay. I believe you. Don't you? I believe the officers ought to be truthful or truth tellers. I take your word for it. You didn't hear it. I heard the noise in the background. I believe you. I'm not here to punish you just for the joy of punishing you. I'm trying to correct behavior, modify behavior. You said you didn't hear it. Great. I believe you. You get a pass on this one. Not sustained. But 6 months later, we have the same problem. We got to get your hearing checked. What's going on here? And we want to modify behavior. We want officers to know this is not worth the grief. Tell them your name.
Yeah. Well, I can certainly keep it as a class 1, but hopefully make this definition a little bit just better, because the theme behind this is the intentional part of it. Is like someone asked, you didn't give it intentionally.
Well, I think the issue is training. And you got to say, look, we believe you. You tell me you didn't hear him and you didn't give him out your name. We believe you, officer. You're not a liar. You're a truth teller. We believe you. You didn't hear it. You didn't give it. Because I know if you heard it, you would have given your name. This is not a hill we want to die on. This seems to be a training issue. And if we take away that class 1, then folks gonna get a license not to give their name and badge number.
Okay. Yeah. Great discussion.
I have to agree with that. Yeah. If the body camera reveals that there was a lot of noise around and he really couldn't, or she, meaning the officer, really couldn't hear someone saying that, that's one thing. In my mind.
Yeah.
And given that scenario, is there a coaching opportunity for a commanding officer to be able to have that discussion, work through it, and
Supervising officer.
supervisor, right? And not violate somebody for that, even though.
Yeah. Counseling is not punitive.
Yeah.
Talking to somebody about something is not punitive.
The slippery slope is when I start thinking about like disparities of discipline and some of the NSA tasks, right? What if we start getting into a thing where it's just like, well, my buddy Brian, you're a good dude, man. I know you wouldn't do that.
Well,
Reggie knows you're a sneaky guy, man. And I don't know.
Well, the distribution or the meting out of discipline is not an exact science. It's an art. And we are going to get it wrong sometimes. And there's going to be some bias in it. And all we can do is try to reduce those things. We're never going to get anything absolutely perfect. It's just not going to happen.
Yeah.
So I want to err on the side of trusting the officers. You say you didn't hear it, we believe you. But you can't have 3 of these, without me saying, I think you need. But you can hear me whispering to you across the room, but no, something's not right here. Somebody's.
And then it becomes a truthfulness
exactly.
issue.
That was going to be my next question. So if somebody says, oh, I didn't hear them say it, and then they look at the body cam and it's like, oh, no, you clearly heard them say it, right? Now, not only is it a class 1 of this violating this, but does it also become a violation of the truthfulness part of it?
It does.
Well, we had the classic example of that, like when the reporter was shot with the less than lethal shotgun, and everybody, that was around it said they didn't see or hear anything.
And it would be on the onus would be on the officer to basically make his case and say, hey, you could check my body cam. I didn't hear it. Like, I'm really telling the truth, right?
Right. If you didn't hear it, why didn't you hear it? That's what I would be asking. What
Yeah.
were you doing?
Here's the one. I'm going to throw this example out, and it may be extreme, but I tend to have a real bad short-term memory sometimes, and I can imagine myself. I'm making an arrest. Somebody's asking me for my name, and then they pull a gun out and start shooting, and all of a sudden it's like this crazy situation, and then later on I'm like, Captain Hubbard, like I heard him say that. I did acknowledge it. And in the midst of all that craziness, I really honestly just forgot that I didn't provide that to him. Like like in that scenario, it would be a class 1 violation, right? I mean,
But that's a mitigating circumstance.
It is.
I'm not giving anybody a class 1 violation. Somebody was shooting at them. No.
But there's only one class 1 option, and that's what I really am getting at here. Is there is no other option, and the other problem is that there's no counseling or mentoring here because it's a class 1 violation. If there's an alleged class 1 violation, it has to be an internal affairs investigation. So I can't informally, as a commander, go up to my officer and said, "Hey, why didn't you give?" It would have to be under the umbrella of an investigation.
Okay. Okay, and then long as you get to the point where somebody was shooting at him and he forgot to tell him his name and badge number, and it's mitigated. See, if we make this thing so impossible, officers are going to rebel. They're going to say, "Wait a minute, you're not being fair to me." I mean, look, I don't think discipline, the design of discipline, is to fire people. That's a byproduct. We want to modify behavior. That's what we want to do. And so if it means we have to go an extra step to get to the point where I understand why you didn't give your name in this circumstance, he did pull out a knife and stabbed you. And so while you're fighting over the knife, you forgot to tell him your name and badge number. I understand that. So,
Yeah. In fact, at that point, it's not even important that you give your name.
right. And
The knife. The last thing you're thinking about is, let me give him my name.
but I don't want to throw the baby out with the bathwater. The purpose of this thing is to get officers to identify themselves.
right.
And okay, maybe we have to start off. Why was this law ever established in California in the first place? It was established in California in the first place because of the riots that occurred, the Mario Savio riots at the University of California at Berkeley. When Alameda County Sheriff showed up and with their sticks and was banging people upside the head, no one knew who did what. That's when we got the law that you have to have your name emblazoned on your shirt and a number that could be readable. I personally had an experience in where in a mutual aid circumstance where a squad of officers came up, they'd taken off their names and everything. I said, "You guys can't go in the theater. I can't use you." And they got all angry and upset. I said, "Look, man, it's the law." That law was written by Sheriff Charles Plummer,
I remember
Alameda County, Hayward Chief of Police, former captain at Berkeley Police Department. So yeah, we want people identified. And so I don't want to make it easy for them not to identify themselves just because we have these rare occasions when somebody is so excited, or there's somebody shooting at them, or there's too much noise and they forget to give their number. So let's reduce it. No, we want to know who did what. That's critically important. Identification is the most important thing. Otherwise, all of these rules and regulations we're writing, we won't have the power to find out who is responsible.
Right.
No, the onus, the responsibility is on each individual officer. You're working here, we're giving you $160,000, $70,000 a year with overtime and whatever. So look, if a citizen asks you your name and your badge number, give it to them. Doesn't cost you anything.
Mhm.
So in those once in a crazy blue moon extenuating circumstances where a supervisor may look and be like, dang, he was stabbing you, you're fighting for your life. I could see why it was reasonable, why you forgot to give him.
Right.
And you're being truthful about it, right?
Right.
Do they have the discretion to be like, yeah, that's not a violation? Where
Apparently, according to Brian,
like
you have to have an investigation.
doesn't feel good, but it's still class 1 violation. You know, like how does
Yeah. Okay. So you have to have an investigation to determine that. So I say I'd rather spend the money on the investigation as opposed to lowering the bar where people have a way of finding ways where they don't have to tell you who they are. Well, I don't want to lower accountability, is what I'm saying.
Yeah, I agree with that. Yeah.
Now, I just want to be clear. We weren't talking about moving it from a class 1 to a class 2. We were just talking about the possibility of adding another class 2 consideration so that
if you add class 2 to it, everything will be class 2. Keep it class 1, keep it just like it is, and see what happens. I don't think it's broken.
Yeah, and that's fine, and I appreciate the conversation. You're right. Compared to the other ones that we talked about, this one is not as confusing. I just know that there's been a few that have come across my desk where, you know, as you read the definition here, there's no room for error. There's no room for whether you're intentional or not intentional, or you forgot, short-term memory, the circumstances. It is what it is. Upon request, supply. And by the way, supply means physically give them something. It's not point to your badge and name tag and
Right.
you read it for yourself. That's what we mean by supply. And any person who seeks identification. And there's no real confusion there. It's just there's been some outlier examples of like, okay, it's reasonable that the officer was not in a position to do that. Maybe they forgot, blah, blah, blah. This section was one of the first sections drafted under the negotiated settlement agreement. We all know why. They're undermining. It's undermining the NSA when you intentionally refuse to do something. But there have been certain situations where there was no malice. It was just a procedural lapse, but we still sustain them for the class 1 section. Which is fine. And maybe the later conversation is the discipline range. Maybe we can talk about that. If we want to say, hey, it's still a class 1, yes, but we can mitigate from there of whether there are circumstances that were reasonable. And therefore you shouldn't serve the same suspension rate as someone who absolutely refuses to do something.
what you thinking, Reggie? What you thinking?
Now, I'm thinking that, look, have the investigation, and if it is determined that the guy legitimately did not hear it or was fighting for his life, or it's reasonable that he possibly didn't hear it and didn't give out his name and badge number, then hey, I think at that point we ought to be able to say this is counseling, you know, or it, you know, and not make it a punitive situation. Yeah. But that's rare.
It is.
Yeah.
It should be rare. So I'm not going to open the door because 1 or 2 situations occur a year, maybe 1 or 2 every 3 years. I don't know. I don't know the rate.
It is.
But I do know why this exists, and I do know the fight, the political fight that went down to make this a state law. I mean, you guys need to understand it was a major struggle.
Yeah. Okay. Well,
Given the circumstances and our history with the riders, like I definitely want it to be a sense of urgency around why this is, very important to us in policing in Oakland. I just I would like to explore if within the discipline matrix itself, if we have a counseling and training option to this so that supervisors have that discretion to ultimately say, you know what, you're not going to get suspended. I believe you. And let's do counseling and training. And that would probably be on the first offense, I'm assuming only.
yeah. So the first offense, it's 398.77. It's suspension 3 to termination. Second offense is 30-day suspension to termination. The last offense is termination.
So it would basically make that first offense training and counseling to termination. And that at least gives the supervisor a little bit of discretion once in a while as extenuating circumstances come up.
Certainly. Yeah. Okay.
I'd be good with that because to everybody's point, by keeping it a class 1, it still speaks to the severity and urgency of why that does matter and why it's so important here in Oakland. It doesn't loosen up and provide any wiggle room, but in these extenuating circumstances, they should still be able to have some discretion around whether they actually serve a suspension or not.
Yeah. Okay. Yeah. Well, I enjoyed the conversation. That is all I had on my list for today. I certainly have a lot of things to do before our next meeting to cover truthfulness and these other issues. Anything else that I can help with this week?
No, but it's been a great discussion today.
Agreed.
I learn something new every time I'm in this space, so I definitely appreciate the
Right.
robust nature of the discussion. Yeah.
Yeah, I agree too. Happy New Year's to everyone, and
Like,
back on the road to getting this done.
All right. Sounds good. Appreciate you all, and we'll be talking soon.
hey,
All right. So our next meeting is when? Next week?
Yeah, and actually, I'm gonna have to get with our chief of staff around that to figure out some technical stuff because it looks like, Ms. Kathy, that was the only day we were able to schedule a community town hall meeting for the pursuit policy.
Oh, where's that going to be?
In North Oakland, at one of the commissioners' home churches. I can't think of it.
Oh, I live in North Oakland. So yeah, I'd be interested in knowing about that.
That's our hometown.
And Brian, maybe if you could use 2 weeks to go through all this stuff, maybe we hold off on next week so that we could all fully participate. Because I was going to figure out how to split my time between the town hall and this group here. But I could imagine that other folks may want to attend that as well too, and not have to choose.
Yeah.
Is it going to be at Downs?
No, let me look.
Phillips Temple?
I think it's a smaller one. I'm not quite. Let me check real quick. I think we put it on our website.
Star Bethel?
No, it's none of those ones ring. Those are I'm familiar with. It's one that didn't ring a bell. I think might be a smaller one.
If you tell me the street, I probably know it if it's in North Oakland.
Yeah.
I'll tell you right. I want to say.
Memorial Tabernacle?
No, I want to say it was at the Religious Church of Science, maybe.
Oh, that's on Telegraph, I think.
Yeah, it is.
Yeah. Telegraph, like
before
40th or something, or West MacArthur.
Oh, okay. Oh. Yeah, I think that's the one where it's at. I don't know why I can't.
Okay.
But it is on our website, so that information's there.
Okay, I'll check it out.
All right.
it-
Well, I'll see you guys. Well, not next week, but the week after next.
I can use a full 2 weeks to fix a
Yeah.
lot. So yeah, thank you for that.
All right, take care.
Sounds like a good deal. Then I'll let Miss Mike, our chief of staff, know, and then we'll update the calendar invites for 2 weeks from now.
Okay, and if
Okay.
she's got a flyer or anything, I can circulate it online.
Okay. Yeah, well, if you're on our listserv, I think she was blasting it out to the listserv today, and then it should be posted on our website as well, too.
Okay.
Great.
All right. Well, thank you all for a great meeting, and I'll see you either next week or week after next.
Good.
Thank you,
Absolutely.
everyone.
All right. Good night, everyone.
Take care. Good night.